everybody, welcome back to Law Hero. My name is Jen. I make videos about the law, and today we are looking at Fe1 Constitutional Law 2024. And yeah, let's just get right into it. So I am going to go down through the paper and have a look at it and see if there's anything weird. So question 1 from autumn 2023 was a problem question about William. So it just says advise him. So let's see, he's a part-time honeymaker. He has permission from the local authority to do so. That may become relevant. Recent months, his sales have been low. He's concerned about the future of his business. Maybe we start thinking there about property rights, as in right to earn a living, livelihood, maybe that kind of thing. This is looking like maybe a rights question, but we don't know yet. He decides he needs to advertise his business more widely, but he doesn't have the money to take an ad in his local paper. So he decides to use mobile advertising to attract passing trade. He puts up a 4-foot wooden board in land near his home with the consent of the landowner. He places lights on the board which spell out local honey for sale. After 2 weeks, his sales increased. But his neighbours are complaining to the local authority about the fact that his sign is lit day and night. So yeah, we have some competing interests here, because like obviously he has the right to earn a livelihood, and the landowner has the right to do what he wants with his land. But then of course we have then the rights of other people to quiet enjoyment of their own dwelling house. He receives a letter from the local authority which states that the sign is contrary to a local bylaw. The letter requests he remove the sign immediately. It also says the local authority will apply for an injunction requiring the immediate removal of the sign if it's not down within 24 hours. So I guess when I read that, I think of probably it's disproportionate. It may attack his property rights. Yeah, it's just a little bit draconian. So yeah, William's looking for your advice. So yeah, I would say possibly Article 40.3, and I would say then he's definitely right to earn a livelihood is being attacked by the local authority, and I would say there's definitely an element of proportionality. It just seems very draconian way to take it down, and an injunction and all of that. But as I said, then we kind of have to consider that your right to earn a livelihood is an absolute, and it can be restricted for public order and the common good. And I would say as well, because this is a public authority, it would definitely be open to judicial review of their decision. Yeah, I would look at the constitutionality of the authority the local authority have, because it doesn't seem constitutional, and I would attack it with the usual constitutional principles. Okay, so question 2 then is Attorney General. So it's a statement about the Attorney General. Attorney General hasn't come up for 4 years, so that's interesting that it's back. It's funny that like even company law and constitutional law this autumn, they brought back questions they haven't done in a while. But like, yeah, so Attorney General is basically Article 30, they're independent. They should be able to do their role without political interference, and they're basically a really pivotal part of the separation of powers. So that's what I would have said there. Okay. Interesting as well that question 3 is a referendum problem question, and I guess that's because of the year that's in it. And I think a lot of people would have rightly assumed that a referendum problem question was going to come up. So who are you advising? You're advising the Citizens Against First Past the Post group. Basically, any of these questions would be kind of arguing the legality of the government's expenditure to one side or another, based on the principles set out in McKenna and McChrystal. And at the end of the day, the government needs to be impartial in any of their funding, and basically they need to ensure that there is an equitable distribution of any information to the public. So I think just reading down through here, there's posters, there's lots of different expenses here, television broadcasts, children and those with pensions are obliged to watch. So yeah, I think you could definitely argue here that funding the Yes campaign violates the McKenna and McChrystal principles, especially if the outcome leads to an imbalance. That's basically what you're looking for here, like the rationale for the legislation. Okay, looking quickly down through question 4. So you're the MEJR. You have to produce a report on the possible reform of the provisions of the Constitution dealing with religion. Okay. This is more of like a discussion on freedom of religion, Article 44, and then all the case law that goes around that. So yeah, you either knew that or you didn't. I would have been low to answer that question if you didn't know that section. You would have been screwed. You wouldn't have passed it. And it really helpfully sets out A to D what they're looking for. So that's like a very easy question, because the question is structured very well. Okay, let's then go on. So I guess what we're waiting for, yeah, I think it must be this one. Non-delegation doctrine question. Yeah, it must be this one. Okay, so Anne is concerned about the possibility of sections being applied to her. She's asked you to advise if there's any grounds on Irish constitutional law she could challenge. So if we go back up, we have an act. Section 4 sets up a board. Section 5 gives them power to review and adjust monthly rent where it believes it appropriate to do so. So they have a certain amount of freedom there. It'll be made up of different the board will be made up by the difference between the amount paid by the tenant and due under the original lease. Section 12 defines land on which planning for more than 10 houses has been allowed to expire within the previous 5 years as ineffectively used. While this is not a criminal offence, they may seize any ineffectively used land without compensation. Massive red flag there. She's a large landowner. She got planning permission from 2013 to 2018, but she didn't build because of the fall of value in property. Okay, so our best bet here is to attack this board. Let me see. Section 4, we don't really care about that. Section 5, let's look at that. The power to review and readjust monthly rent owed to a landlord. That would definitely affect your property right as a landlord, I think. Like if you have a third party deciding what the rent is going to be, you could definitely argue property rights there, I would say. And same with section 12, saying that the power to seize any ineffective use land without compensation. I don't see any other right other than property rights there. Section 5, adjusting the rent where it believes it to be appropriate to do so. I would say that this is in contravention to the non-delegation doctrine under Article 15.2, and then all of the case law that goes along with that, the administrative requirements of the Act, rather than acting in a legislative sense. Next question, question 6. So we're advising Greg here. It's quite a lengthy problem question. I scan down through it, it's a hypothetical public order act. Section 16 provides that inference may also be drawn from the fact of an accused subsequently provides an explanation what was not provided to the Gardaí. So this to me seems like presumption of innocence question. What are grounds of Ireland's conviction is judicially reviewed? Yeah, I would say fair trial, right to silence, use of inference under this act undermines his rights. Like here, the local superintendent testifies that in his opinion, possession of a Che Guevara poster is usually consistent with support for student radicalism and a willingness to engage in violent demonstrations. That could be prejudicial to a fair trial, I think. The next question was problem question, or a case law question, and I always tell people to avoid that one. Same with EU, just because like the probability of passing it's very low. And then question 8 was an essay question, the creation and evolution of a constitutional right to privacy. Okay, so this is just basically an essay on privacy and whether you agree. Most striking example of the way in which the Irish court's treatment of the Constitution as a living instrument has evolved and changed over time. Yes, it has, because of the doctrine of unenumerated rights. Yeah, so of course you would start with Mickey, Norris, Dave Norris, Kennedy, and how the courts have recognised and expanded the right to privacy over time, and this shows like the adaptability of a constitution in protecting fundamental rights. And I think most people would have scored well in that question. Again, like I always say, to score highly you would have needed that critical analysis, and you would have also have needed the input from academic scholars. I actually think that was a very nice constitutional law paper. Let me know what you think in the comments, and I will see you in the next one.